When it comes to what's happening in Wayne County and the North Carolina area, look no further than Taylor House Publishing. If you have a story that needs to be told, please contact us via email at taylorhousepublishing@gmail.com.
All right, so ladies and gentlemen, welcome once again. Today I want to talk about the case of Mr. Antwan Yelverton. Now, Antwan Yelverton is a childhood friend of mine who is currently on his 22nd year, if I'm not mistaken, of a 35-year sentence received in 2002. Now, he was sentenced for first-degree attempted murder, assault with a deadly weapon with intent to kill, discharging a firearm into an occupied property, and habitual felon. Now, what I have right here is Mr. Yelverton's motion for appropriate relief. Now, if anybody has been in the system or has served a long sentence, you would understand what a motion for appropriate relief is. But if you have not, don't advise you to get yourself in any of these predicaments. But a motion for appropriate relief is essentially a motion made after the judgment to correct any errors that occurred before, during, or after a criminal trial or proceeding, including errors related to the entry of a guilty plea or sentencing. So basically what this is in a man who's been sentenced last-ditch attempt to rectify any mistakes that he feel has been made within the trial by prosecutors, things of that nature. So I'm going to go over his claims, but I'm also going to give you some background information on the incident. Now, this incident that I'm reading is actually from his original appeal, and that appeal was filed right after the sentence, the conviction in 2002. I think this judgment was made by the appeal courts in March of 2004. So as soon as you get sentenced, they automatically file an appeal. And if you've ever been in that situation, you know 99 times out of 100 that appeal is going to be denied. But the statement of facts is written in the appeal. Now it says on May 24th, 2001, the defendant shot Marcus Coleman in the chest during a drive-by shooting. Mr. Coleman was a passenger in a second vehicle at the time of the incident. Defendant testified that he acted in self-defense and that he believed Mr. Coleman was armed and intended to shoot him, which is one of his claims. Mr. Coleman was hospitalized approximately 1 week for treatment of the bullet wound to the chest. At the close of evidence, the jury convicted the defendant, Mr. Yelverton, of first-degree murder, assault with a deadly weapon with intent to kill, inflicting serious injury, 4 counts of discharging a weapon into occupied property, and possession of a firearm by a convicted felon. Following the guilty plea, Mr. Yelverton did plead guilty to habitual felon. Now, how they sentenced them is they sentenced them separately on each particular charge. So the charge for first-degree murder, first-degree attempted murder, they sentenced him to a term of 225 months to 279 months. That's basically 18 years and 18 years to 23 years, right? Secondly, they sentenced him on the assault with a deadly weapon with intent to kill, inflict a serious injury. They sentenced him to 115 months to 147 months. That's basically, once again, about 12 to 15 years. And then they ran the rest of the convictions concurrently. Now, the first two charges, the first two sentences were ran consecutively. That means after he finished after he finished that 18 years and 9 months, then he starts on the 12 years and 3 months. Now, the other ones were run concurrent. That means when he starts the first sentence, those other sentences start also. So there's basically a non-factor. But the fact that he was sentenced, and I'm going to start with this claim, the fact that he was sentenced to basically the same charges twice is a part of the criminal process that I think it in itself is criminal. Now think about it. He has attempted first-degree murder, right? And then he has a separate charge, assault with a deadly weapon with intent to kill, inflicting serious injury. Those are basically the same thing. If you attempt to murder someone, apparently you're assaulting them with a deadly weapon with intent to kill them and inflict serious injury. So that is how a lot of prosecutors do to ensure that they're going to get the maximum penalty or ensure that they're going to get a conviction. But it is a statute, is a case law that a person is not to be tried for two separate crimes when the evidence is identical and the evidence can convict both. Like, there's no difference in the evidence that you're using to convict him of assault with a deadly weapon and first-degree attempted murder. There's no difference in the factual evidence to support those charges. Now, that is one of Mr. Yelverton's claim, and I may put that up on the screen and some information. And once again, this is a 34-page affidavit concerning his conviction. And this is actually a page that illustrates that. It says, on or about the 24th day of May 2001 in Wayne County, Antwan Yelverton did with a .380 caliber handgun shoot Marcus Coleman in the chest, causing a gunshot wound. Now, that is the evidence that they are using for attempted murder. No, excuse me, assault with attempted assault with a deadly weapon with intent to inflict serious injury. Now, this is what they're using for attempted murder. On or about the 24th day of May 22 in Wayne County, Antwan Yelverton did unlawfully, willfully, and feloniously, and of malice of forethought did attempt to kill and murder Marcus Coleman with a .380 handgun, shooting Marcus Coleman in the chest, causing a gunshot wound. Those are basically the same facts on each charge. So why do they stack charges like that? And you'll see that throughout criminal cases, especially in Goldsboro. So that is one of his claims, that, you know, he should be free from double jeopardy. Now, if that is the case, being that he has already served 20 years, this motion for appropriate relief would grant him freedom if it is accepted. And this was filed early this year, so he should be receiving a response. But the fourth claim is also very, very, very instrumental. Now, keep in mind, Mr. Yelverton was represented by now disbarred Charles Gurley. Now, if you haven't seen the earlier video which I did that states the reasons why Charles Gurley faced violations from the bar, you can read it yourself. He says he grossly advocated to non-lawyer staff his trust accounting obligations, and he did not represent dozens of clients diligently. And from the reports in this report, Antwan Yelverton was one of those clients. Now, as stated, Mr. Yelverton asserted the fact that he acted in self-defense. He said he was riding, they ran up on Marcus. Marcus, brandished the gun, and it was his interpretation of Mr. Coleman's action that Mr. Coleman was going to shoot him. Therefore, he opened fire, and in his opinion, he protected himself. Now, as stated, Marcus Coleman was shot in the chest. He was then hospitalized, and I actually talked to Marcus Coleman on a separate video that I did that was concerning him in some regards, and we spoke, and that's my guy. We had a little conversation. He disagreed with some things in the video, but I'm only using your name in this video, my brother, as a statement of fact to this case. Now, and also I do gotta give my man Marcus a shout out, because at the time of this incident, these were two street dudes, and according to the street code, if something goes down in the streets, you got a beef, you don't show up to court. And for all intents and purposes, from speaking with Mr. Yelverton and these documents, Mr. Coleman, in the words of the street lingo, Mr. Coleman kept it G. He didn't show up to court. He didn't testify against Mr. Yelverton, and I don't know the history of the conflict, but evidently, he chose to once again abide by, in my opinion, the much maligned and destructive street code. Nevertheless, Mr. Yelverton, the investigator who spoke with Mr. Coleman, received two statements from him. And one, he admitted that he did have a gun, and the gun was a .357. And he also stated, allegedly, in this statement, according to this motion, that he also had crack cocaine in the car with him. And it is alleged that he told the investigator, that investigator is Teresa Chiro, that he had a .357 handgun and crack when he got shot, and someone came and retrieved those items from the vehicle. Now, this investigator, Officer Detective Chiro, admitted to having this statement, and on cross-examination, Attorney Charles Gurley asked Ms. Chiro to produce the statement. Now, the statement also should have been provided to the defense in the motion of discovery. Now, once again, if you don't know what the motion of discovery is, that means you've never been in trouble. If you haven't never been in trouble, then I don't advise you to get in trouble. But a motion of discovery is when your defense lawyer has the right to have all of the evidence that the prosecution plans to present at trial, so they can have the opportunity to cross-examine witness, research his witness, and basically put on a proper defense. So, however, Mr. Gurley actually never got this statement, and on the trial at the stand, he asked the judge, or asked the investigator, to produce that statement so he can defend his client's claim of self-defense. And the investigator admitted that she did have the statement, but she didn't have it in her possession. And also the judge asked her, did she have a statement from Mr. Coleman on two separate occasions? And once again, she identified that she did have that, but she didn't have it present to present at court, which was essential to Mr. Yelverton's claim of self-defense. If the injured party, the victim of Mr. Yelverton's assault, made a statement that confirmed that he had a weapon in the car, then that evidence will be considered as exculpatory. Now, exculpatory is another legal term that means evidence that would free him from any wrongdoing, basically. And so that is the basis in this violation. He claims that it is a Brady violation. And my brother did his work. He actually did this by himself. He cites case law. He is very well witnessed, very well thought out and put together. But he cites case law. So this is basically suppression of evidence, which is a Brady violation. That the defense cannot conduct the reasonable and diligent investigation to preclude of finding a procedural default when the evidence is in the hand of the state. Meaning, his lawyer tried to get the evidence, and in one statement, Attorney Gurley says she won't give it to me. Now, I don't know how court procedure works, but and another aspect of this case is one of the judge on this case was now, I think, retired or defunct Judge Jerry Braswell. Now, Jerry Braswell should have exercised his judicial authority to make sure that this evidence was presented at trial. Evidently, he did not force Detective Chiro to present that information, and therefore he should be also, take some of this responsibility. Now, he also claims, and once again, just off the fact that Gurley was his lawyer, he should immediately get appropriate relief because this man that is recently disbarred, we've all heard the many rumors or allegations of him being under the influence of certain substances in and out of the courtroom. We've heard those things, and so that definitely should be taken into consideration with Mr. Yelverton not being represented properly in this. But he also he gives two more claims, and the other claim is that the trial court erred in failing to issue an appropriate written commitment order for imprisonment. Now, what does that mean? Anytime that you are sentenced, they have to write or commit all of the sentences in an order. Now, Mr. Yelverton claims that on the conviction paper, they said, they convicted him for attempted first-degree murder, attempted first-degree murder, and they labeled and attempted assault with a deadly weapon, inflicted serious injury, and things like that. But he claims on that order that the trial court, they failed to list the charge in the right manner. They listed it as a Class B1 felony instead of a Class B2 felony. And so, therefore, that made the committal null and void. Now, also, he claims that the sentences which were committed to run consecutively, they were by the orders intended to run concurrently. And so, once again, that committal is null and void. Once again, it is classed as a B2 felony, not a B1 felony. And then they also, another claim is they failed to include, anytime that order is written, you have to include both the minimum and the maximum penalty in the law. And they said that in this claim, he claims that they did not present the maximum penalty in these sentences. And so Mr. Yelverton's claims are very well warranted. Now, I'm not here to say what he did was right or wrong. I was not there. But according to the law, according to the letter of the law, he definitely has some claims. He said he has not received a ruling. I think he sent it to Matt Delbridge. Now, Matt Delbridge is also the current head district attorney now, if I'm not mistaken, and he was the head district attorney or the district attorney on that case. And there was also a signature by now, I think she's an insurance salesman or something, saleswoman, Terry Light. There's a signature in here where she signed off on something. And I've heard, some things about both of them. Now, especially Matt Delbridge, when he used a photo of the 17-year-old girl wrongly convicted for life, Miss Kalonda Wooten, as his campaign slogan on his campaign page for election or re-election in 2014. I thought that was very despicable by using a 17-year-old child who was illy, grossly misrepresented and underrepresented in a trial to show that, okay, well, yeah, this is a conviction. I sent this 17-year-old child to jail for life, to prison for life, for something that she didn't even do. And so, that definitely left a salty taste in my mouth when I looked him up and I saw that on his Facebook page. And so, but he is also a player in this, and we all know all of the corruption that goes on, all of the things. And one thing I must say, though, now I don't know if this is true. I haven't confirmed this with my brother, Mr. Yelverton. However, when I, spoke to several people about the case, it was told to me that they did offer him a plea of 5 to 7 years. Now, I don't know if that is true or not. However, we have seen, and, I don't know, once again, if he felt the claim of self-defense was warranted, but we have seen that whenever you don't take that plea that they give you and you exercise your right to a fair trial, when they find you guilty, you can see right here where they throw the book at you. And that is a problem, once again, with the justice system. You should not be extra penalized or over sentenced just because you chose to exercise that right. As we see it with my brother, I think Leandre Wilson, Lil Dre. I think he had a shooting case not too long ago, and it was informed to me, or it was rumored, that they gave him the offer of 5 to 7 years. And he took it to the box, as we say. If you don't know what that means, then don't get in trouble. But that means he took it to trial. He took it to the box. He got found guilty, and I think they gave him 75 years. Now, at the age of 40 plus, unfortunately, without any appropriate relief. Unfortunately, one of my other, childhood associates would die in prison. Now, that is definitely something wrong. How could you say, okay, well, if you take this plea, we're going to give you 5 to 7 years. So evidently the offense was not that serious. But if you take it to trial, we're going to give you 75 years. That is egregious. That is malicious sentencing of the courts. And, that is what is possibly the case here. Once again, just the mere fact that you're charging him with attempted murder and assault with the deadly weapon with intent to kill, inflict, or serious injuries. Those are essentially the same things. So, I know hopefully a lawyer will get up here and try to defend these actions, a prosecutor. There's no defense of this. This young man has served 20 years. I'm not saying that it's right. Fortunately, Mr. Coleman, another childhood associate, did survive. So, there was not death in this situation. But we have seen also people, get 7 years for for similar things when people do die, 10 years, 15 years, 20 years. So the fact that this man was sentenced consecutively for essentially the same charge definitely reeks of, over sentencing. We see, the prosecutorial and the judicial misconduct of them not allowing that statement from Mr. Coleman. If that was a true statement, once again, I'm going off the information that is written in this motion. I haven't seen the trial transcript. This is solely based on, once again, this motion for appropriate relief sent by Mr. Yelverton. So, hopefully he will receive a favorable outcome in this sense. Like I said, 20 years. I think, that should be more than enough. If not, he would, have to, I think his projected release date, if this information is correct, would be, let me see, 2032. So and that would be in February. So he's looking at another 8 years if he does not receive a favorable outcome. But nevertheless, this is a prime example of things that you're doing in your youth. I think at the age of his conviction, he was probably 20, and so that means he's probably spent half of his life in jail. So we have to be very careful playing around with these guns, this youth, things of that nature, man. There's definitely a terrible, terrible thing to go through if not only for him but his family and those who love him. So peace and blessings, man. 919-587-7782. Feel free to reach out. I'm out. Make sure that you like the video, share it, and subscribe.